I was standing in my kitchen on a Tuesday morning in Phoenix, Arizona, pouring my second cup of coffee when I heard the unmistakable sound of a power saw coming from my backyard. The high-pitched whine cut through the quiet suburban air like a knife, and my first thought was that maybe my neighbor Dave was doing some early construction work. But then I remembered Dave had left for a business trip to Denver the day before, and the sound was definitely coming from my property, not his. I set my coffee mug down on the granite countertop and walked quickly toward my back door, feeling my heart rate pick up with each step. Through the glass sliding door, I could see two men in reflective safety vests standing at my fence line, and one of them was holding what looked like a reciprocating saw. The other guy was marking something on my cedar fence with a thick black marker, measuring with a tape measure between marks. My blood ran cold when I realized what they were doing. They were cutting holes in my fence. Actual rectangular holes, about 2 feet wide and 3 feet tall, systematically spaced along the western side of my property line. I could already see 3 completed cutouts, the fresh cedar wood exposed where they had sawed through, and they were working on a 4th. I yanked open the sliding door so hard it rattled in its frame. "Hey, what the hell are you doing to my fence?" Both men looked up, and the one with the saw switched it off. The sudden silence was almost as jarring as the noise had been. The taller of the two men, a stocky guy with a gray beard and a clipboard tucked under his arm, stepped forward with the kind of casual confidence that told me he thought he had every right to be there. "We're installing ventilation panels, as per HOA Regulation Code 7-12-B, he said, reading from his clipboard. "All fences over 6 feet in height require adequate airflow ventilation to prevent wind damage and ensure compliance with the revised community standards." I stared at him like he had just spoken in ancient Greek. "Ventilation panels. You're cutting holes in my fence without my permission and calling them ventilation panels." The second man, younger with a patchy brown beard, shifted uncomfortably and looked at his partner. The older guy, however, did not seem remotely concerned. "Sir, this is HOA-mandated work. You should have received notice about the new regulations in your mailbox last month." "I received no such notice," I said, walking down my patio steps and across my lawn toward them. "And even if I had, you cannot just come onto my property and destroy my fence without my explicit consent. This is my fence on my property that I paid for with my own money. My name is Nathan Edwards, and I had lived in the Saguaro Springs community for 3 years. I had bought this house, a modest 3-bedroom ranch-style home with a decent-sized backyard, specifically because I wanted privacy and a place for my 2 dogs to run around safely. The cedar fence I had installed 18 months ago had cost me nearly $8,000, professionally installed with quality materials that were supposed to last for decades. The older contractor pulled out a laminated work order from his clipboard and held it up for me to see. "Look, sir, we're just doing our job. This work order was issued by the HOA president, and we have authorization to access all properties on this block for compliance work. If you have issues with the regulation, you need to take it up with the HOA board, not us." I pulled out my phone from my pocket and started taking pictures. I photographed the holes in my fence, the contractors, their truck parked in the alley behind my property, and the work order they were holding. The older guy tried to pull the work order back, but I had already gotten several clear shots. "I am going to tell you this once," I said, keeping my voice level despite the anger boiling inside me. "Get off my property right now, or I am calling the police. You are trespassing, and you have damaged my personal property without authorization." The younger contractor looked genuinely worried now, but the older one just shook his head. "Buddy, you are going to be in violation of HOA codes if we do not finish this work. That means fines, potential liens on your property. You really want to go down that road?" "What I want," I said, already dialing 911 on my phone, "is for you to leave my property immediately." The older contractor muttered something under his breath that I did not quite catch, but both men started gathering their tools. The younger one picked up the reciprocating saw, while the older one rolled up his measuring tape. They walked toward the back gate, which I noticed they had opened without permission to access my yard in the first place. "Phoenix Police, what's your emergency?" The dispatcher's voice came through my phone. "I need to report trespassing and destruction of property," I said, watching the contractors disappear through my back gate. "Two men just cut multiple holes in my fence without permission." The dispatcher took my information and address and told me an officer would be there within 20 minutes. I spent that time documenting everything I could. I took more photos of the damage, measured the holes they had cut, counted them 4 total rectangular cutouts, each about the same size, and looked for any notices or documentation that might have been left at my property. I found nothing. When I walked around to the front of my house, the contractor's white pickup truck was pulling away from the alley. I managed to get a photo of the license plate and the company name painted on the side. Premier Property Services, LLC. Officer Martinez arrived about 15 minutes later, a no-nonsense woman in her mid-30s with dark hair pulled back in a tight bun. She listened to my explanation while examining the damage to my fence, taking her own photos with a department camera and making notes on a tablet. "And you say you never gave permission for this work?" she asked. "Absolutely not," I said. "I paid for this fence myself. It's entirely on my property, and I never received any notice about any HOA regulations regarding ventilation panels or whatever they were calling it." Officer Martinez walked the length of my fence, examining each hole carefully. "These are pretty significant. This is definitely property damage. Do you know the approximate value?" I pulled up the original invoice on my phone from the fencing company that had installed it. The entire fence cost $8,000. I would estimate the damage at probably $2,000 minimum to repair, maybe more depending on whether they weakened the structural integrity. She nodded and made more notes. "I am going to write up a report for criminal damage to property. You will get a case number that you can use for insurance purposes and for pressing charges if you decide to go that route. I also recommend you contact your HOA directly and get to the bottom of who authorized this." After Officer Martinez left, I stood in my backyard staring at the holes in my fence, feeling a mix of anger and disbelief. My 2 dogs, a golden retriever named Bailey and a German shepherd mix named Cooper, were sniffing curiously at the openings, and I had to call them back before they figured out they could potentially squeeze through. I went back inside and immediately started searching through my email and the pile of mail I kept in a basket on my kitchen counter. I went through every piece of mail from the past 2 months. There were the usual bills, some junk mail, a few catalogs, but absolutely nothing from the Saguaro Springs Homeowners Association about fence regulations or ventilation requirements. I opened my laptop and pulled up the HOA website, logging into the resident portal with my credentials. The last communication I had received from the HOA was 3 months ago about the annual dues increase. There was nothing posted about fence regulations, nothing about ventilation panels, nothing that would indicate the work that had just been done to my property was legitimate or authorized by any official vote. Frustrated, I looked up the contact information for the HOA president. According to the website, that was a woman named Karen Livingston, a name that was somehow not surprising given the situation. Her email was listed, but I decided this warranted a phone call. I found the HOA office number and dialed. The phone rang 4 times before someone picked up. Sagaro Springs HOA, this is Karen speaking. Karen Livingston, I asked. Yes, this is she. How can I help you? I took a deep breath, trying to keep my composure. My name is Nathan Edwards. I live at 4782 West Mesquite Drive, and I need to speak with you about some unauthorized work that was done to my property this morning. There was a pause on the other end of the line. Oh, you must be calling about the ventilation panel installation. Yes, that work is being done throughout the community to bring all fences into compliance with our new wind safety regulations. Mrs. Livingston, I never received any notice about this work, and I never gave permission for anyone to cut holes in my fence. 2 contractors showed up on my property this morning without notification and damaged my fence to the tune of at least $2,000. Mr. Edwards, I can assure you that proper notice was given, she said, her tone becoming clipped and defensive. We sent out a community-wide mailing 6 weeks ago detailing the new regulations and the implementation timeline. I received no such mailing, I said firmly. And even if I had, you cannot authorize work on my private property without my explicit consent. This fence is entirely on my property, paid for with my own money, and the HOA has no authority to damage it. Karen's voice took on a condescending edge that made my jaw clench. Mr. Edwards, when you purchased your home in Sagaro Springs, you agreed to abide by all HOA covenants, codes, and restrictions. The HOA board has the authority to enforce community standards, which includes structural modifications for safety purposes. Your fence exceeds the height limit of 6 feet, which triggers the ventilation requirement. My fence is exactly 6 feet tall, I said. I made sure of that when I had it installed specifically to comply with HOA regulations. According to our survey, your fence measures 6 feet 2 inches at multiple points along the western property line, Karen countered. That puts it over the limit and subject to the ventilation requirements. I walked outside with my phone and grabbed my measuring tape from the garage. I measured the fence at several points while Karen waited on the line. Every measurement came back at exactly 6 feet, not an inch over. I am measuring my fence right now, Mrs. Livingston, and it is exactly 6 feet at every point. Someone gave you incorrect information. Well, that's not what our survey indicates, she said dismissively. Regardless, the ventilation panels are now required for all solid fences regardless of height. This is about community safety and maintaining property values. Cutting holes in fences maintains property values. I asked incredulously. Mrs. Livingston, I have already filed a police report for criminal damage to property. Those contractors trespassed on my land and damaged my fence without authorization. I am going to repair the fence to its original condition, and I expect the HOA to pay for those repairs in full. Karen's voice turned icy. If you repair that fence without installing the required ventilation panels, you will be in violation of HOA regulations, and I will have no choice but to fine you. The fines start at $100 per day for non-compliance. Then I suggest you get a lawyer, Mrs. Livingston, because I am not paying for your contractors to vandalize my property, and I am not leaving my fence damaged because of some made-up regulation. I hung up before she could respond, my hands shaking with anger. I immediately called my homeowner's insurance company and reported the damage. The claims representative was sympathetic and said they would send an adjuster out within 48 hours. Then, I called 3 different fence repair companies to get estimates on fixing the damage. The first company, Arizona Fence Pros, sent someone out that same afternoon. The estimator, a guy named Rick with sun-weathered skin and 30 years of experience, examined the holes carefully and shook his head. "Whoever did this really did a number on your fence," he said. "These are not just cosmetic holes. They cut through support structures, and the way they did it has compromised the stability of these entire sections. You are looking at replacing 4 full panels, not just patching the holes." "How much?" I asked. Rick did some calculations on his tablet. "Parts and labor, you are looking at around $2,800. That's to properly replace these sections with matching cedar and reinstall them correctly." I thanked Rick and told him I would get back to him once the insurance adjuster had assessed the damage. The other 2 companies I called gave similar estimates, ranging from $2,600 to $3,000. That evening, I drafted a formal demand letter to the HOA. I outlined the events of the morning, attached photos of the damage, included the police report case number, and demanded full reimbursement for the repair costs, plus compensation for the time I was having to spend dealing with this situation. I sent it via email and also printed a copy to send via certified mail. The next morning, I received a response from Karen Livingston. Her email was formal and completely unapologetic. "Dear Mr. Edwards, your complaint has been reviewed by the HOA board. The work performed on your fence was authorized under HOA authority to maintain community standards and safety. You will not be reimbursed for any repairs, as the ventilation panels are required to remain in place per community regulations adopted by board vote on March 15th. Failure to comply will result in daily fines as previously stated. The board stands by its decision and its authority to enforce community standards. Sincerely, Karen Livingston, HOA President." I read the email 3 times, each time feeling more incredulous. They were not even pretending to acknowledge that what they did was wrong. They genuinely believed they had the right to cut holes in my fence. I forwarded the email to a real estate attorney I found through a quick online search, a man named Robert Chen, who specialized in HOA disputes. His office was in downtown Phoenix, and he agreed to meet with me the next day. Robert Chen's office was on the 14th floor of a modern glass building with a view of the city sprawl. He was in his early 40s, impeccably dressed in a navy suit, and he listened intently as I explained the entire situation, showing him the photos, the police report, and the email exchange with Karen Livingston. When I finished, he leaned back in his chair and steepled his fingers. "Mr. Edwards, this is one of the most blatant cases of HOA overreach I have seen in quite some time. They have absolutely no legal authority to damage your personal property, regardless of what their internal regulations say." "That's what I thought," I said. "But I wanted to make sure I was not crazy." "You are definitely not crazy," Robert said. "Here is the situation from a legal standpoint. Yes, when you purchased your home, you agreed to abide by HOA covenants, codes, and restrictions. However, those CCRs do not supersede your property rights or give the HOA carte blanche to damage your property. Any regulation they want to enforce has to go through proper channels, which includes proper notice, opportunity for homeowners to respond, and in cases involving property modification, explicit consent." "They claim they sent out notice," I said. "You have any proof you received it?" Robert asked. "None. I have gone through every piece of mail from the past 3 months, checked my email, checked the HOA portal. Nothing." Robert made notes on his legal pad. "Even if they did send notice, which I doubt, that still does not give them the right to physically alter your property without your consent. That is destruction of property, which is a criminal matter, as the police report reflects. It is also a civil matter because you have suffered financial damages. So what are my options? I asked. We have several paths we can take, Robert said. First, I will send them a formal legal demand letter outlining their liability and demanding immediate payment for repairs and removal of the illegal regulation. Second, if they do not comply, we can file a civil lawsuit for the damages plus additional compensation for your time and suffering. Third, we can pursue the criminal angle with the prosecutor's office to have charges filed against whoever authorized this work. I want to do all three, I said without hesitation. Robert nodded approvingly. I like your attitude. This kind of behavior from HOAs needs to be challenged, or they will continue to think they can do whatever they want. Let me draft that demand letter today, and we will get it sent out immediately. In the meantime, I would recommend you repair your fence to its original condition. Document everything, keep all receipts, and do not let them intimidate you with threats of fines. I left Robert's office feeling more empowered than I had since this whole nightmare started. I called Rick from Arizona Fence Pros and scheduled the repair work for the following week. Over the next few days, things escalated quickly. Robert sent his demand letter to the HOA board via certified mail and email. The response came not from Karen Livingston, but from the HOA's attorney, a man named Douglas Porter from a firm that apparently specialized in representing homeowner associations. Porter's letter was dismissive and aggressive. He claimed the HOA had full authority under the CCRs to enforce safety regulations, that proper notice had been given, and that I was the one in violation by refusing to comply with community standards. He threatened immediate legal action if I repaired the fence without the ventilation panels, and stated that the HOA would seek to recover all legal fees from me. Robert's response was swift and brutal. He sent back a point-by-point rebuttal, citing case law from Arizona courts that had ruled against HOAs in similar overreach situations. He also included a timeline showing I had received no notice, and pointed out that the HOA's own website had no record of the regulation being properly posted or voted on according to their own bylaws. While this legal back and forth was happening, the fence repair crew showed up at my house. Rick and his team spent an entire day carefully removing the damaged sections and installing new panels that perfectly matched the existing fence. When they were done, you could not even tell where the holes had been. The fence was restored to its original condition, solid and secure, exactly 6 feet tall along the entire property line. The total cost came to $2,700. I paid it with my credit card and got a detailed receipt with photos of the work for my records. 2 days after the fence was repaired, I came home from work to find a citation taped to my front door. It was from the HOA, stating that I was in violation of Community Regulation 7-12-B for failing to maintain required ventilation panels, and that I was being fined $100 per day starting immediately. The citation was signed by Karen Livingston and dated that day. I took a picture of the citation and immediately sent it to Robert. He called me within an hour. "Nathan, this is actually good for us," he said. "They are doubling down on an illegal regulation which strengthens our case significantly. Do not pay these fines. We are going to fight this." "Should I expect them to keep harassing me?" I asked. "Probably," Robert admitted. HOAs like this often escalate before they back down. Just document everything, do not engage with them directly, and forward everything to me. He was right. Over the next 2 weeks, I received 3 more citations, each one adding another $100 per day in fines. The total they claimed I owed was now over $2,000. I also received a notice that the HOA was filing a lien against my property for non-payment of fines. Robert filed an emergency motion in court to block the lien and to obtain a temporary restraining order against the HOA from further harassment. The hearing was scheduled for a Monday morning at the Maricopa County Superior Court. I took the day off work and met Robert at the courthouse. We were assigned to Judge Patricia Morrison's courtroom, and I sat nervously at the plaintiff's table while Robert organized his documents. The HOA was represented by Douglas Porter, the attorney who had been sending the aggressive letters. He was a tall man with slicked-back gray hair and an expensive suit, and he looked supremely confident as he set up his own materials. Judge Morrison entered, and we all stood. She was a woman in her 60s with sharp eyes and a no-nonsense demeanor. She reviewed the filings quickly before looking up at both attorneys. "This is a hearing on the plaintiff's motion for a temporary restraining order and to block a property lien," she said. "Mr. Chen, you may proceed." Robert stood and laid out the entire situation clearly and concisely. He presented the photos of the damage, the police report, the timeline showing lack of notice, and the citations and fines that had been issued. He also presented evidence that the regulation in question had never been properly voted on or adopted according to the HOA's own bylaws. "Your Honor, this is a clear case of an HOA exceeding its authority and engaging in what amounts to vandalism of private property," Robert concluded. "The HOA caused approximately $2,700 in damage to my client's fence, has refused to take responsibility, and is now attempting to extort money from him through illegal fines and a baseless lien. We ask the court to issue a temporary restraining order preventing any further harassment and to block the lien pending a full hearing on the merits." Judge Morrison turned to Douglas Porter. "Mr. Porter, your response." Porter stood, buttoning his suit jacket. "Your Honor, the HOA has clear authority under the community's CCRs to establish and enforce safety regulations. The ventilation panel requirement was properly adopted and noticed to all residents. Mr. Edwards's refusal to comply puts the entire community at risk and sets a dangerous precedent that homeowners can simply ignore regulations they disagree with. You have proof that Mr. Edwards received notice of this regulation?" Judge Morrison asked. Porter shuffled through his papers. "The notice was sent via bulk mailing to all residents 6 weeks before implementation." "Bulk mailing," Judge Morrison repeated. "Do you have any confirmation that Mr. Edwards specifically received this notice?" "Well, no, Your Honor, but the mailing was sent to all addresses in the community." "And do you have proof that this regulation was properly voted on and adopted according to the HOA's bylaws?" Porter hesitated. "The board has the authority to adopt safety regulations without a full homeowner vote under emergency provisions." "Was this an emergency?" Judge Morrison asked. "It was deemed necessary for community safety." Judge Morrison looked unimpressed. She turned back to the documents in front of her, reading through them with a frown. After a moment, she looked up. "Here is what I see," she said. "An HOA authorized contractors to physically damage private property without explicit permission from the property owner, without clear proof of proper notice, and allegedly under a regulation that may not have been properly adopted according to the organization's own rules." When the property owner repaired the damage, the HOA began issuing fines and threatening a lien. "Mr. Porter, I am having a very hard time seeing how any of this is legal or appropriate." "Your Honor, the HOA has broad authority," Porter began. Judge Morrison held up a hand. Broad authority does not mean unlimited authority, Mr. Porter. HOAs are not above the law, and property owners have rights that cannot be trampled simply because a board decides something is necessary. I am granting the temporary restraining order. The HOA is hereby ordered to cease all fines and citations against Mr. Edwards related to this fence issue, pending a full hearing. The lien is blocked and may not be recorded. We will schedule a full hearing for 3 weeks from today, at which point both sides can present complete evidence and testimony. Until then, the HOA will not contact Mr. Edwards regarding this matter except through his attorney. I felt a wave of relief wash over me. Robert squeezed my shoulder as we stood for the judge's exit. Outside the courtroom, Porter approached us with a tight expression. "This is not over, Mr. Chen. Your client is going to lose, and he is going to be responsible for all legal fees when he does." "We will see about that, Douglas," Robert said calmly. "You might want to advise your client to settle before this gets worse for them." Over the next 3 weeks, Robert worked on building our case for the full hearing. He subpoenaed records from the HOA showing their board meeting minutes, all mailings and communications, and financial records related to the contractor who had done the work. What he found was damning. First, there was no record of any board vote on the ventilation panel regulation. The meeting minutes from March 15th, the date Karen had claimed the regulation was adopted, showed no such discussion or vote. In fact, that meeting had been canceled due to lack of quorum. Second, there was no evidence of any community-wide mailing about the regulation. The HOA's financial records showed no expense for printing or postage that would correspond to sending out hundreds of notices to residents. Third, and most interesting, the contractor who had done the work, Premier Property Services LLC, was owned by Karen Livingston's brother-in-law, Michael Sutton. The HOA had paid Premier Property Services nearly $40,000 over the past 6 months for various compliance work throughout the community, all of it apparently authorized solely by Karen without board approval. "Nathan, I think we have stumbled onto something much bigger than just your fence," Robert said when he showed me what he had found. "This looks like Karen has been funneling HOA money to her brother-in-law through these fake compliance projects. Your fence might just be the tip of the iceberg." "That's fraud," I said. "Yes, it is," Robert agreed. "And it's something we need to bring to the attention of the court and possibly law enforcement." Robert filed an amended complaint adding allegations of fraud and misappropriation of HOA funds. He also sent a copy of his findings to the Maricopa County Attorney's Office for potential criminal investigation. The full hearing arrived on a Wednesday morning. This time, the courtroom was more crowded. Several of my neighbors had shown up after word had spread about what was happening. I recognized at least 6 other homeowners from Saguaro Springs sitting in the gallery. Karen Livingston was there, sitting behind the defense table next to Douglas Porter. She looked furious, her face pinched and her arms crossed tightly across her chest. She was a woman in her mid-50s with blonde hair styled in an aggressive bob, and wearing a pantsuit that probably cost more than my monthly mortgage payment. Judge Morrison called the hearing to order and asked Robert to present his case. Robert walked the judge through everything methodically: the unauthorized damage to my fence, the lack of proper notice, the fake regulation that was never actually voted on, and then the bombshell about the financial irregularities and the connection between Karen and the contractor. He called me to the stand first. I testified about the morning I found the contractors cutting holes in my fence, the lack of any notice, my conversations with Karen and the police, and the subsequent harassment through fines and lien threats. Porter cross-examined me, trying to suggest I had received notice and simply ignored it, but I held firm. "I keep meticulous records of all my mail and emails," I said. "I went through everything multiple times. There was no notice." Robert then called an expert witness, a property management consultant named Dr. Helen Foster, who had reviewed the HOA's records and procedures. She testified that the HOA had violated its own bylaws in multiple ways, and that the so-called regulation had no legal standing. "In my professional opinion," Dr. Foster said, "this regulation was fabricated by the HOA president without proper authority, likely to justify payments to a contractor with whom she had a personal relationship." Porter objected strenuously, but Judge Morrison allowed the testimony to stand pending corroboration. Robert then presented the financial records showing the payments to Premier Property Services and the business registration showing Michael Sutton as the owner. He also presented a family tree chart showing the relationship between Karen Livingston and Michael Sutton through Karen's sister, Patricia Sutton. The final witness Robert called was a man I had not expected to see, the younger contractor who had been at my fence that morning. His name was Eric Brennan, and he looked nervous as he took the stand. "Mr. Brennan, you were one of the contractors who cut holes in Mr. Edwards's fence, correct?" Robert asked. "Yes, sir," Eric said quietly. "Can you tell the court how that job was arranged?" Eric glanced at Karen, who was staring daggers at him, then looked back at Robert. "We got a work order from our boss, Mike Sutton. He said the HOA president had authorized a bunch of compliance work throughout the community and that we needed to install ventilation panels in fences." "Did Mr. Sutton tell you whether the homeowners had been notified?" "He said they had all been sent letters and that we had authorization to access the properties." "Did you personally see any documentation showing homeowner consent?" Eric shook his head. "No, sir. We just had the work orders from Mike." "And how many fences did you modify in this manner?" "Mr. Edwards's was the fourth one we had done. We were supposed to do about 20 more." A murmur went through the courtroom. Robert let that sink in for a moment before continuing. "Mr. Brennan, why did you agree to testify today?" Eric looked uncomfortable. "Because after Mr. Edwards called the cops, I started asking Mike more questions about whether we had proper authorization. He got really defensive and told me to just do the work and not ask questions. That did not sit right with me. I looked up some of the HOA regulations online, and I could not find anything about ventilation panels. I think we were doing work that was not legitimate, and I did not want to be part of that." "Thank you, Mr. Brennan," Robert said. Porter tried to discredit Eric during cross-examination, suggesting he was a disgruntled employee or had been coached by Robert, but Eric stuck to his story. He seemed genuinely troubled by what had happened. After Eric stepped down, Judge Morrison asked if Porter wanted to present any witnesses for the defense. Porter called Karen Livingston to the stand. Karen took the oath and sat down with her back ramrod straight, radiating indignation. Porter asked her to explain her version of events. "The board became concerned about fence safety after several fences in the community were damaged during a windstorm last year," Karen said. "We consulted with contractors and were advised that solid fences over a certain height should have ventilation to prevent wind damage. We adopted a regulation to address this concern and contracted with a reputable company to perform the work." "Did the board vote on this regulation?" Porter asked. "The board delegated authority to me as president to handle safety matters," Karen said. "Mrs. Livingston, is it true that Michael Sutton, the owner of Premier Property Services, is your brother-in-law?" Robert asked during his cross-examination. Karen's expression tightened. "Yes, But that has nothing to do with anything. Mike's company was hired because they offered competitive rates. Did you solicit bids from other contractors? I did not feel that was necessary for routine compliance work. Mrs. Livingston, do you have any documentation showing that homeowners were notified about this regulation before work began? We sent out a mailing, Karen insisted. Can you provide any evidence of this mailing? Receipts, copies of the letter, anything? Karen hesitated. The administrative records should have that information. Your own financial records show no expense for such a mailing, Robert said. In fact, your records show no board authorization for the $40,000 paid to your brother-in-law's company over the past 6 months. Can you explain that? Those were authorized expenses for community maintenance, Karen said, but her voice had lost some of its confidence. Maintenance that no one else on the board knew about, Robert pressed. Maintenance that involved damaging private property without permission. I was acting in the community's best interest, Karen said, her voice rising. Everything I have done has been to protect property values and ensure safety. By cutting holes in people's fences and funneling money to your relative, Robert asked. Objection, Porter shouted, standing up. Argumentative. Sustained, Judge Morrison said, but she was looking at Karen with an expression that made it clear the damage was done. After both sides rested, Judge Morrison took a brief recess to review the evidence. When she returned, she looked grim. I have reviewed all the evidence and testimony presented today, she began. This is one of the most troubling cases of HOA overreach I have encountered in my years on the bench. It is clear to me that Mrs. Livingston, acting as HOA president, exceeded her authority in multiple ways. She fabricated a regulation without proper board approval, authorized work on private property without homeowner consent, failed to provide proper notice, and engaged in what appears to be a pattern of directing HOA funds to a family member's business without oversight. Karen's face had gone pale. I am ruling in favor of Mr. Edwards on all counts, Judge Morrison continued. The HOA is ordered to pay Mr. Edwards the full cost of repairs to his fence, $2,700, plus an additional $5,000 in compensatory damages for the time, stress, and harassment he has endured. The HOA is also ordered to pay Mr. Edwards's legal fees, which his attorney will submit for approval. She turned her attention to Karen. Mrs. Livingston, I am also ordering an independent audit of the HOA's finances for the past 2 years, to be conducted by a court-appointed auditor at the HOA's expense. Any irregularities found will be referred to the appropriate authorities. Furthermore, I am referring this matter to the Maricopa County Attorney's Office for investigation into possible fraud and embezzlement charges. Karen stood up suddenly. Your Honor, this is ridiculous. I have done nothing wrong. I have served this community faithfully for 5 years. Sit down, Mrs. Livingston, Judge Morrison said sharply. You authorized the destruction of private property, misled homeowners, and appear to have misappropriated community funds. If you have done nothing wrong, the investigation will clear you. If you have, you will face the consequences. This hearing is concluded. The courtroom erupted in whispered conversations. Several of my neighbors came up to me, shaking my hand and thanking me for standing up to Karen. Apparently, I was not the only one who had been dealing with her overreach and intimidation tactics. She tried to fine me $500 because my mailbox was the wrong shade of beige, one woman told me. The wrong shade of beige, another man said. She sent me a violation notice because my garbage cans were visible from the street for more than an hour after pickup. I work until 6 o'clock. What am I supposed to do? It became clear that Karen had been terrorizing the neighborhood for years, and people were relieved that someone had finally challenged her successfully. Over the next few weeks, things moved quickly. The court-appointed auditor began reviewing the HOA's financial records, and what they found was even worse than anyone had suspected. Karen had been funneling money to her brother-in-law's company for almost 3 years, not 6 months. The total amount exceeded $120,000, all for compliance work that was either unnecessary, improperly authorized, or simply never performed at all. The audit also revealed that Karen had been approving her own expense reimbursements without board oversight, paying herself for things like luxury dinners, spa visits, and shopping trips, all claimed as business expenses for the HOA. The Maricopa County Attorney's Office opened a formal criminal investigation. A detective named Sarah Rodriguez contacted me to get my statement about the fence incident and to gather any evidence I had. I provided her with all my photos, the police report, and the court documents. "Mr. Edwards, you may have done this whole community a huge favor," Detective Rodriguez told me. "Financial crimes like this often go unreported or unnoticed until it is too late. The fact that you pushed back when she tried to intimidate you has exposed what looks like a systematic pattern of fraud." About 6 weeks after the court hearing, I was at home on a Saturday morning when I saw police cars pull up to Karen Livingston's house, 3 doors down from mine on the same street. I watched from my front window as Detective Rodriguez and 2 uniformed officers went to the door. Karen answered, and there was a brief conversation before she was placed in handcuffs and led to one of the police cars. She was arrested on charges of theft, fraud, embezzlement, and criminal damage to property. The news made the local Phoenix television stations that evening, with reporters standing outside the Saguaro Springs community entrance talking about the HOA president who ran an alleged embezzlement scheme. The HOA board, what remained of it after Karen's arrest, held an emergency meeting and issued a formal apology to all residents. They voided all citations and fines that Karen had issued without proper authority, which totaled over $50,000 across dozens of homeowners. They also announced they were dissolving the contract with Premier Property Services and reviewing all work that had been authorized over the past 3 years. Michael Sutton, Karen's brother-in-law, was also arrested a few days later on charges of conspiracy to commit fraud. It turned out he had been submitting invoices for work that was never done or grossly inflating the costs of work that was performed. The legal proceedings took several months. Karen eventually pleaded guilty to multiple counts of theft and fraud in exchange for a slightly reduced sentence. She was sentenced to 3 years in state prison and ordered to pay full restitution to the HOA, over $130,000 including interest and penalties. Michael Sutton took a plea deal as well and received 2 years in prison plus restitution. The HOA paid me the $2,700 for my fence repairs, plus the $5,000 in damages that Judge Morrison had awarded. They also paid Robert's legal fees, which totaled about $12,000. I actually felt bad about that, because it was the innocent homeowners in the community who ultimately had to cover those costs through their dues. But Robert assured me it was important to hold organizations accountable when they exceed their authority. If we let HOAs get away with this kind of behavior, they will just keep doing it, he told me. Sometimes standing up for yourself benefits everyone. The community held a special election to replace Karen and restructure the board. The new president was a retired accountant named George Martinez, who immediately implemented new oversight procedures and transparency requirements. He also pushed through a bylaw change requiring board approval for any expenditure over $500 and mandating regular financial audits. My fence remained intact, solid and secure at exactly 6 feet tall, with no ventilation panels. No one from the HOA ever bothered me about it again. Bailey and Cooper continued to enjoy their secure backyard, completely unaware of the legal drama their fence had sparked. I did get some interesting mail about 6 months after everything concluded. It was a notice from the restructured HOA board informing residents that they were implementing new protections for homeowner rights, including requirements for explicit written consent before any HOA-authorized work could be done on private property, mandatory notification periods for new regulations, and an appeals process for disputed citations. At the bottom of the notice, there was a handwritten note from George Martinez. "Thank you for your courage in standing up to the previous administration. Your actions have helped us create a better, more accountable community association." I also received dozens of thank you cards from neighbors who had been victims of Karen's arbitrary enforcement and intimidation. Many of them shared their own stories of ridiculous fines and citations. One woman had been fined for having a vegetable garden in her backyard because Karen deemed it unsightly, even though the backyard was not visible from any street or common area. Another man had been cited for parking his work truck in his own driveway because Karen decided commercial vehicles were not allowed, a rule that did not actually exist in the CCRs. The entire experience taught me several important lessons. First, HOAs do not have unlimited power, regardless of how much they act like they do. Property owners have rights that are protected by law, and those rights do not disappear just because you live in a community with an HOA. Second, standing up to bullies and petty tyrants is important, even when it is expensive and time-consuming. If I had just accepted the damage to my fence and paid Karen's bogus fines, she would have continued her pattern of abuse and fraud unchecked. By fighting back, I not only protected my own property but helped expose corruption that was harming the entire community. Third, documentation is everything. The photos I took that first morning, the police report I filed, the meticulous records I kept of all communications and expenses, those things were crucial in building a successful case. Without that evidence, it would have been my word against Karen's, and the outcome might have been very different. Finally, I learned that most people are reasonable and willing to support someone who is being treated unfairly, but they need someone to take the first step. Once I challenged Karen openly, and the extent of her misconduct became clear, many neighbors came forward with their own complaints and evidence. But before that, everyone had been suffering in silence, either not realizing they could fight back or being too intimidated to try. About a year after the whole ordeal began, I was working in my backyard on a sunny Saturday afternoon, doing some gardening while Bailey and Cooper lounged in the shade of my perfectly intact fence. My neighbor Dave came over, the one who had been on a business trip that fateful Tuesday morning when the contractors showed up. "You know, I never thanked you properly for what you did," Dave said, leaning against the fence. "Karen tried to fine me $2,000 last year because she said my house needed repainting. My house did not need repainting. She was just on a power trip. I paid it because I did not think I had any choice. After your case went public and the new board took over, they reviewed all of Karen's citations and refunded me that money." "I am glad it worked out," I said. "It is more than that," Dave continued. "You showed all of us that we do not have to just accept it when someone abuses their authority. That is worth more than any refund." As Dave headed back to his own yard, I looked at my fence, solid and whole, exactly as I had built it. The cedar had weathered beautifully over the past couple years, taking on a nice silver-gray patina. There were no holes, no ventilation panels, just a good fence doing its job of providing privacy and security. I thought about that Tuesday morning, standing in my kitchen and hearing that saw cutting through my fence. The anger and disbelief I had felt in that moment. The determination to not let someone get away with damaging my property just because they had a title and an inflated sense of authority. The whole experience had been stressful, expensive, and time-consuming, but it had also been worth it. Justice had been served, corruption had been exposed, and a community had been freed from a tyrant. My fence was whole again. Karen was in prison where she belonged, and the Saguaro Springs HOA was now run by people who understood that they existed to serve the community, not to rule over it. Sometimes standing up for what is right is not easy. Sometimes it means taking on people who have more power, more resources, and more arrogance than seems possible. But as I learned that year in Phoenix, Arizona, righteousness and persistence can prevail. Property rights matter, the law matters, and individuals have more power than they realize when they refuse to be bullied. I never did get an apology from Karen herself. She maintained throughout her trial and sentencing that she had been trying to help the community and that her prosecution was unjust. Some people never accept responsibility for their actions, no matter how clear their guilt becomes. But I did not need her apology. I had my fence, my property rights intact, and the satisfaction of knowing that I had stood up not just for myself but for every homeowner who had been victimized by her abuse of power. That was enough. The last I heard, Karen was working in the prison laundry and attending required financial responsibility classes as part of her sentence. Michael Sutton was in a different facility doing similar low-level work. The money they were ordered to pay in restitution was being garnished from their prison wages at a rate that meant it would take them decades to repay what they stole. The Saguaro Springs community thrived under new leadership. George Martinez proved to be an excellent HOA president, transparent and fair. The community actually came together in ways it had not before, with neighbors looking out for each other, and the board actually listening to concerns rather than issuing arbitrary edicts. My legal bills were fully covered by the HOA as Judge Morrison had ordered, so the whole ordeal did not cost me anything out of pocket except time and stress. Robert Chen and I stayed in touch, and he told me he used my case as an example in presentations he gave to other attorneys about HOA law and property rights. As for my fence, it stood strong and true, exactly 6 feet tall, a monument to the principle that property owners have rights that must be respected. Every time I looked at it, I felt a sense of pride and accomplishment. That fence represented more than just wood and nails. It represented standing up for what was right, refusing to be intimidated, and proving that even the most arrogant petty tyrant can be held accountable. Bailey and Cooper never knew the full story, of course. They just knew they had a secure yard to play in and an owner who would protect their home. And really, that is what it was all about from the very beginning. Protecting my home, my property, and my rights as a homeowner. The holes that Karen's contractors had cut that Tuesday morning were long gone, repaired and invisible. But the impact of what happened that day rippled through the community for years, changing how the HOA operated and empowering homeowners to speak up when something was not right. I continued to live in my house in Saguaro Springs, enjoying the Arizona sunshine, the company of my dogs, and the peace of mind that came from knowing my property was truly mine. The fence that had started this entire saga stood as a quiet reminder that sometimes the biggest battles start with the smallest violations, and that standing firm in defense of your rights is always worth the fight. Looking back on everything, I would not change a thing. Yes, it was difficult. Yes, it was stressful, but it was also necessary. Karen Livingston needed to be stopped, and the only way that was going to happen was if someone stood up to her. I am grateful it was me, and I am proud of how it turned out. My fence remains perfect to this day, and so does my resolve to never let anyone push me around again, HOA or otherwise.